to abolish torture. This is we're a law school group that's basically a coalition of students who are concerned about torture and other issues that are really relevant right now. And I'm here to introduce Ray McGovern. He is our moderator today, and he's a retired CIA analyst who worked for 27 years with the CIA. He's a leading voice for peace against all the wars that we're functioning in right now. He founded and leads, let's see if I can get this name right here, Veteran Intelligent Professionals for Sanity, VIPS, right? And he's our moderator today, so please give Ray a hand.
Thanks so much, and it's terrific to be introduced by the next generation. And I want to express all of our appreciation for the students here who have risen to the occasion, and the occasion is really, really important. So let's begin here. I'd like to ask first Marjorie Cohn, who most of you people know as the professor at Thomas Jefferson Law School in San Diego. She's a noted author. Marjorie, thank you very much for being here.
Thank you, Ray, and thank you all for organizing this very important event and for inviting me to be part of it. What does torture have in common with genocide, slavery, and wars of aggression? They are all considered to be jus cogens. Jus cogens is Latin for higher law or compelling law. That means that no country can ever pass a law that permits torture. There can be no immunity from criminal liability for torture, and there is no statute of limitations for torture. The United States has always prohibited torture in our Constitution, in our laws, in executive statements, and in judicial decisions. We have ratified 3 treaties that outlaw torture and cruel, inhuman, or degrading treatment or punishment. And when the United States ratifies a treaty, it becomes part of U.S. law under the Supremacy Clause of the Constitution. The Convention Against Torture says no exceptional circumstances whatsoever, whether a state of war or a threat of war, internal political instability, or any other public emergency may be invoked as a justification for torture. Whether someone is a POW or not, he must always be treated humanely. There are no gaps in the Geneva Conventions. He must be protected against torture, mutilation, cruel treatment, and outrages upon personal dignity, particularly humiliating and degrading treatment. We have federal laws that criminalize torture. The U.S. War Crimes Act punishes torture, willfully causing great suffering or serious injury to body or health, and inhuman, humiliating, and degrading treatment. The federal torture statute provides for life in prison or even the death penalty if the victim dies for anyone who commits, attempts, or conspires to commit torture outside the United States. The Army Field Manual prohibits the use of force, mental torture, threats, insults, or exposure to unpleasant and inhumane treatment of any kind. Military personnel who mistreat prisoners can be prosecuted under the Uniform Code of Military Justice. The Constitution gives the Congress the power to make the laws and the President the duty to carry them out. Yet on February 7th, 2002, George W. Bush, relying on memos by lawyers, including your very own John Yoo, announced that the Geneva Conventions did not apply to Taliban and Al-Qaeda members. Bush said, however, quote, "As a matter of policy, the United States Armed Forces shall continue to treat detainees humanely and to the extent appropriate and consistent with military necessity in a manner consistent with the principles of Geneva," unquote. But torture is never allowed under our laws. Lawyers in the Department of Justice's Office of Legal Counsel wrote memos at the request of high-ranking government officials in order to insulate them from future prosecution for subjecting detainees to torture. In memos, John Yoo and Jay Bybee, who worked in the Office of Legal Counsel, Jay Bybee now has a lifetime appointment on the Ninth Circuit Court of Appeals, they advised the Bush administration and that the Department of Justice would not enforce the U.S. criminal laws against torture, assault, maiming, and stalking in the detention and interrogation of enemy combatants. This is the behavior that your law professor, John Yoo, did not want to punish. You said in an interview in Esquire that quote, just because the statute says, that doesn't mean you have to do it, unquote. This is a law professor. In a debate with Notre Dame professor Doug Cassell, you said there is no treaty that prohibits the president from torturing someone by crushing the testicles of the person's child. In Yu's view, it depends on the president's motive, notwithstanding the absolute prohibition of torture. You also said that the president could also order the massacre of a village full of civilians. This is law professor John Yoo. You twisted the law and redefined torture much more narrowly than the definitions in the Convention Against Torture and the U.S. torture statute. After the exposure of the atrocities at Abu Ghraib and the publication of this torture memo by John Yoo and Jay Bybee, the Department of Justice knew that the memo could not be legally defended. So it was withdrawn, and a new opinion written by Daniel Levin, Acting Assistant Attorney General, Office of Legal Counsel, specifically rejects John Yoo's definition of torture and admits that a defendant's motives to protect national security will not shield him from a torture prosecution. The rescission of that memo constitutes an admission by the Justice Department that the legal reasoning in that memo was wrong. But for 22 months, it was in effect, and it sanctioned and led to the torture of prisoners in U.S. custody. The National Security Council Principals Committee, consisting of Dick Cheney, Condoleezza Rice, Donald Rumsfeld, Colin Powell, George Tenet, and John Ashcroft, met in the White House and micromanaged the torture of terrorism suspects by approving specific torture techniques such as waterboarding, long considered to be torture. And Bush admitted, yes, I am aware our national security team met on this issue and I approved. These top officials are liable for war crimes. Under the U.S. War Crimes Act, torture is considered a war crime, and torture under the torture statute. They ordered the torture that was carried out by the interrogators. And under the well-established doctrine of command responsibility, used at Nuremberg and enshrined in the Army Field Manual, commanders all the way up the chain of command to the commander-in-chief can be guilty of war crimes if they knew or should have known their subordinates would be committing them and they did nothing to stop or prevent it. Holder should appoint a special independent counsel, a special outside prosecutor, outside of the Department of Justice to investigate and prosecute these people and bring them to justice. Because if we don't do it in this country, other countries will bring them to justice under the very well-established principle of universal jurisdiction, which Israel, for example, used to convict and execute Adolf Eichmann for his crimes during the Holocaust, even though they had no direct connection with Israel, which the United States used to try, convict, and sentence to 97 years Chucky Taylor of Liberia for torture committed in Liberia that had no connection with the United States.
For those of you who think maybe these are sort of speculative, theoretical things, who remembers what happened to Rumsfeld in Paris 3 years ago? Anybody raise your hand? Okay, there are a couple of people who remember that. He showed up at the U.S. Embassy, he was going to give a big speech somewhere, and someone had the presence of mind to notify the procurator of Paris that there was a war criminal in town. That procurator was, as I understand it, in turn obliged by law to ferret out this war criminal and bring him to trial. Rumsfeld learned of this, and he was out the back door at Charles de Gaulle, flying home within half an hour.